Welcome back. So we're going to be talking copyright now. Now, the Copyright Amendment Bill is currently being debated in the National Council of Provinces, and the Select Committee on Trade and International Relations recently called for further written submissions on the bill. And experts say it is crucial that amendments are made as infringements are on the rise. And joining us now is Hugh Melamdowitz, who is a partner at intellectual rights firm Spoor and Fisher. Welcome, Hugh. Thanks so much for helping us wade through this morning.
Thanks for having me. It's good to be here. Bright and breezy, early morning.
And I think we should start at the beginning, though, by answering a simple question. What is a copyright?
Yeah, I think that's very important to understand the basic principles around copyright, because many people get it wrong, just don't really understand precisely what copyright is all about. And I think we need to start from the basic principle is copyright doesn't protect ideas. I've been criticized a little bit around that principle, but it really doesn't protect ideas. What it does protect is the material expression of those ideas. So what is actually created is what copyright protects. And let me give you an example. We've got the Women's World Cup coming up, and I decide that there's a great way to promote the World Cup and to promote some business. So I approach the SABC, or the SABC sends out an invitation, either solicited or unsolicited approach, with an idea that I have to have a competition where the winning prize is a ticket to the World Cup, Women's World Cup in France, and there's some baby prizes as well. I can get a signed shirt or a chance to go and watch one of the warm-up matches. And there are various prizes, and all I need to do is to answer 3 general knowledge questions, and I can go through. So I pitch that to the SABC. SABC kind of thinks, not a bad idea, but not great at the moment. And anyway, as things unfold, they eventually decide, actually a good idea. They're going to go and produce it themselves. There's nothing to stop the SABC from doing it. That would not be an infringement of my intellectual property rights, of my copyright. It would not be an infringement of my copyright. However, if I was going to go and make a copy of one of the shows that the SABC has produced, then I would be infringing on the SABC's copyright, because the SABC would have copyright in the what's going to be called audiovisual work that they create, the movie that they create, the film that they create of that particular competition. So SABC would be the copyright owner of that particular movie. What the Copyright Amendment Bill does is it doesn't really change any of those basic principles. It retains that, but it tries to, first of all, take into account the digital era. We've moved into a whole new era of distribution of content and storage of content. And what we need to, what we would hope is that the Copyright Amendment Bill will address some of the concerns there. And then also what we are hoping for is that it will properly regulate collecting societies, the societies that go and collect royalties for creators of works, for the owners of copyright. There's been a fair amount of criticism recently around some of those collecting societies. Some of it may be justified, some of it may be unjustified, and what we really would hope is that the collecting societies are properly regulated to the satisfaction of all.
How do you go about registering a copyright then?
Okay, so important, copyright is not registrable. Copyright subsists automatically. Copyright is just one of a whole bunch of intellectual property rights, which include, amongst others, trademarks and patents. And the reason I've mentioned trademarks and patents is because they are registrable. So in order to get intellectual property protection for a trademark, you need to register the trademark, and same as for an invention. You need to actually register the invention. So you put the invention down in writing, and you go and register it, and only once it's registered, you get the statutory protection. Copyright, however, is different. Copyright subsists automatically. So as soon as I create a work, as soon as I take a picture, do a drawing, I'm the owner of that drawing as long as it's original, as long as I haven't copied it from something else, and as long as I've spent time and effort creating it. The actual quality of the work is pretty much irrelevant. And then I'm the owner of that work. And I think where the Copyright Amendment Bill starts to become a little bit concerning for me is that it tends to confuse the two principles around copyright. One is access to the work, license and access to the work, and the other is ownership of the work. Ownership. So the basic principle where I come from is if I create it, I own it, and if you want to use it, you need my permission to use it.
Yeah.
I may or may not wish to give you permission, and there could be a whole host of reasons why I don't want to give you permission to use it.
Hugh, just finally, with regard to the salient aspects of the amendments that are being sought, what are those?
Okay, so as I said, there are a couple of areas that I think are important, and the legislation has done well. So the first aspect is around the control of the collecting societies. I think that is there's a lot of positives coming out of that. And then around the Copyright Tribunal, which is a court that will look at copyright disputes, which I think is important. I think they've started to go some way towards addressing the concerns around the digital era. For example, I know one of the big concerns was streaming, and one of the areas where they're trying to get around arguing that streaming is not an infringement of copyright is to amend the legislation to allow for communication to the public, which is fairly broadly defined. So any communication to the public without permission could constitute copyright infringement, and that would be the streaming. But I think the area in which they have made is problematic for me, the areas where they start to encroach on contractual rights, and that's why I mentioned, if I don't want you to use my work, then I should have the right not to allow you to use it. There have been a lot of encroachments there. Some I think are reasonable, maybe reasonable, but they're going to have certain unintended consequences. For example, the rights around education, the rights to make copies around education, and I understand that there's a strong argument to allow free access to works for education purposes. However, I'm not going to write a book on intellectual property unless I'm going to get compensated.
Absolutely.
And Juters or whoever is not going to publish that book unless they're going to get compensated. And if I can argue that as a student I'm entitled to make as many copies or make copies of that work, I don't need to buy it to be able to study, it diminishes the income that the publisher is going to receive, and there's going to be unintended consequences there.
Well,
just a quick one. The big one is the issue around fair use and fair dealing, and that is probably the area that is most problematic, because it means that all disputes are resolved in the courts, which for me is problematic.
And I think we're going to have to take a lot more time to actually explain those technicalities. But thank you so much, Hugh Melamdowitz, for stopping by from intellectual property rights law firm Spoor and Fisher, talking to us about the Copyright Amendment